Please welcome David French and David Keating.
First, let me just say, I'm excited about today because we have an absolute star-studded lineup of some of the heaviest hitters and greatest thinkers in the conservative movement, some of the people who are making policy happen in the United States and the world. And we're beginning with two civil libertarian nerds talking about donor privacy. So we're going to kind of begin by answering that universal James Stockdale question, who are we and why are we here? I'm David French, this is David Keating, and we're here to talk about one of the most important constitutional issues that you're not tracking enough. I can promise you're not tracking it enough. And we're going to start with a signature piece of legislation that just passed through the Democratic House that was stopped in its tracks by Mitch McConnell. But we're still going to talk about it because Mitch McConnell isn't going to be on that wall for the next 100 years. We need to educate America about rediscovering a commitment to political speech in the First Amendment. And by the way, I'm also going to state that this panel is going to be probably the only panel this entire 2 days that is at least partially endorsed by the ACLU. But don't hate us, please. So I'm going to begin, and we're going to begin by talking about a bill called H.R. 1. This is a sprawling 570-page bill that was the signature achievement of the Democratic House. They were one of the reasons why they were upset at Ilhan Omar's anti-Semitic comments, because it was distracting them from their prime mission of demolishing the First Amendment. In this bill called For the People Act, bill called the For the People Act, which was this comprehensive, huge bill about election reform that had elements within it that were striking at the heart of the First Amendment. And David has been doing tremendous work on this, and I'm going to give him the extremely enviable task of, can you in 90 seconds describe all the worst elements of a 600-page bill?
No.
Okay, 2 minutes. 2 minutes then.
No. Well, first of all, we're not calling it the For the People Act. We're calling it For the Politicians Act.
I prefer the Constitutional Demolition Act.
Well, it's both.
Okay.
It's more, right?
Yeah.
So basically it has subsidies of speech, but only for politicians, because there's money, public money, that's going to be handed out to politicians so they can speak and hopefully, from their point of view, get reelected. But for the rest of the bill that regulates campaign speech, it makes it more difficult to speak, basically, in a nutshell. And another thing about it is, one of the, I think, big problems we have today with campaign finance laws, grassroots lobbying laws, is you read these laws and you think, wow, let me go back to the tax code, because that's something that's a lot simpler to understand. Mm-hmm. Enforced by people who are more reasonable.
Yes.
And so H.R. 1 takes this complexity and magnifies it by many, many times. So what you're going to see is, if this becomes law, groups will spend way more on attorneys and much less on advocating their mission. So it has things like defining things like, if you promote, attack, support, or oppose a candidate, that's regulated speech. Well, what does that mean? Promoting or attacking, supporting or opposing? All kinds of language like that. And when your group does that, then you have to basically report your donors. And it's not, you hear about this 60 days before an election, it's going to be regulated. This new language would regulate speech at any time. 365 days a year, 24 hours a day. Doesn't matter if you're in election time or not.
Well, and we're all very familiar with the shame campaign culture now. We're very familiar with the process of digging through people's old tweets to discover whether or not they're going to be employable at a new job they take 10 years later or 5 years later. We're all very familiar with the phenomenon of looking for wrongthink and looking for wrong beliefs and punishing them. I mean, we just saw that recently when the San Antonio City Council, come on, Texans, the San Antonio City Council voted to ban and bar Chick-fil-A from its airport because Chick-fil-A, they had found that Chick-fil-A's foundation in 2017 had donated to two extraordinarily heinous organizations named the Salvation Army and the Fellowship of Christian Athletes. So you have this recent example of digging through to find past donations as a way of implementing government reprisals and government punishment. And there's some parts of H.R. 1 that are so broad that when I wrote a piece about it, I called it like government doxing. That there's actually ways, and maybe you can describe this, in which you can be a donor to an organization and believe you're donating for one purpose and then be inadvertently outed as a sort of a political donor when the organization takes minimal political action in other spheres. This is something the ACLU pointed out. It's almost like an involuntary outing against your consent because of the actions of an organization you don't control.
Exactly, but it's actually worse than that. If you give money to an organization and the organization later on runs an ad that's regulated under this new scheme, the organization has to list or speak the major donors in the ad. Now, if there were, FTC regulations, Federal Trade Commissions for, truth in advertising, not misleading the public, well, what they make you put on the ad, in many cases, will actively mislead the public because the two people or the top 5 donors listed on the face of the ad may have given to something completely different. Mm-hmm. And yet their name has to go on the ad. So it's not only giving information, it's giving bad information, it's giving misleading information. And another thing about this whole disclosure thing, we talked about this briefly outside before we came on. When this whole concept of disclosing money to candidates and parties and PACs first came about, it was in the 1970s. And the Supreme Court said the threshold for how much would be given, right, they thought it was almost unconstitutionally low back then. Well, guess what? We've had a lot of inflation since the 1970s. The disclosure threshold has barely changed. And guess what? To find out who's donated to a candidate, party, or PAC, you don't have to go to the Federal Election Commission over on North Capitol Street and look through their filing cabinets. You just take out your smartphone or computer and it's all there online.
Well, we've talked about how this is it sounds bad, it sounds like bad policy, it sounds unfair, but I also want to talk a bit about why I believe it's grotesquely unconstitutional as well, particularly given the facts that exist now in American life regarding, as I mentioned before, the shame campaigns, punitive actions that are undertaken against people for engaging in speech that others don't like. I think Americans have forgotten that many of our freedom of association rights, many of the rights that we take for granted, including the right to be free from government inquiries about our activities, were developed through the civil rights movement. And specifically in the 1950s, the NAACP was asked by the state of Alabama to disclose its members and associates, mandatory disclosure, or it wouldn't be permitted to operate in Alabama. And now, you don't have to be a historian to know what that would mean in 1950s Alabama. Now, to be clear, I want this to be 1 billion trillion % clear. I am not comparing our online shame culture today to the plight of civil rights workers in the South in the 1950s. But what I am saying is if you read that opinion, the listed harms that occur to people through mandated disclosure all exist today, not in the same degree, not in the same level of danger, but things like physical threats, things like economic boycotts and reprisals, these things exist today. You can see them all around. And so what harms of government doxing is that you're exposed to the very harms that Supreme Court case authority has been developed to prevent. And so, I think that's one aspect of unconstitutionality. And another one that you guys have talked about is the constitutional problems of vagueness and overbreadth. And maybe if you could sort of give a bite-sized analysis of that.
What I'd like to do is
that's great.
I hate to do this to you, but I'm going to anyway.
No, this is worth it.
This is a bill that's on the desk of the New Jersey governor right now. I don't think he's signed it yet. But this is a definition of what is going to be regulated in New Jersey. An organization that, quote, engages in influencing or attempting to influence the outcome of any election of any person to any state or local public elective office, or the passage or defeat of any public question, or legislation, or regulation, or providing political information on any candidate, public question, legislation, or regulation. So
That's all? That's all it regulates?
I don't know what they
Why are
left
we
out.
Yeah.
But basically, if you say anything about something that might become a law, a bill, or somebody getting elected, the state of New Jersey wants to know. And this is the sort of thing, that we're seeing more and more of. New Jersey actually covered a law that's now under litigation in New York. And that law, before it became law, the interesting thing was there was a coalition letter signed to the governor urging him to veto it because they thought it was too broad, too vague, it covered too much public discussion. And guess who signed it? Common Cause, League of Women Voters, Public Interest Research Group of New York, and of course the New York Civil Liberties Union and others were all critical. But you know something's gone too far when Common Cause says it's gone too far.
And there's another thing that I think is really important to outline about all this, because we talked about the complexity of these laws. And look, I have been looking at campaign finance laws for much of my adult life just as part of a byproduct of doing constitutional litigation and First Amendment litigation. There are many of these things that I have to read 2 and 3 and 4 times before I can really grasp what they're trying to do, which makes the regulatory decision maker, the initial regulatory interpreter of these regulations and enforcer of these regulations, all the more important. And there's this aspect about H.R. 1 that I think is under-discussed about the changes to the Federal Election Commission that the Democrats want to enact that would mean that the decision maker is much more likely to, that's interpreting these incredibly complex regulations, is much more likely to be partisan in its mindset and partisan in its actions than the current FEC. And if you could explain the changes that they're proposing in the FEC and what that means, I think that can help explain even more the constitutional danger here.
Well, and just the real danger. I mean, look, you have to keep in mind when the Federal Election Commission was created, the atmosphere that was created was right after the Nixon presidency. And one of the things they remembered is Nixon had an enemies list, and he was happy, I won't use the famous words, but he was happy to use the powers of government to do things to people on his enemies list. And Congress thought, hey, we have an imperial president. The last thing we need to do is give someone like Richard Nixon the ability to go over his political opponents using the levers of the Federal Election Commission to basically shut them down. So they consciously said, we're going to have a commission with only 6 members and basically 3 Republicans and 3 Democrats. So one party can't use it to silence the other party. H.R. 1 throws that out. 5 members. Now, no more than 2 can be of one party, they say. But hey, how hard is it to find an independent like Bernie Sanders, right? Add him to the Federal Election Commission. Which way do you think he's going to lean, right? So this would not be difficult to make the Federal Election Commission partisan or ideological. Then the second thing that's underappreciated about this is the chair of the FEC would be given enormous new powers. The chair would have the ability to issue subpoenas without consent of the commission. The chair would be able to hire the staff director, and that sounds like yawn, staff director. Well, let me explain in a way you can understand. The chair of this new FEC could hire Lois Lerner and put her in charge of deciding what groups to audit.
Fair.
Okay. Do we want that to happen? I say no, we probably don't want that to happen. Today, these key staff members have to be supported on a bipartisan basis. So the danger is we could see, it could actually be Lois Lerner. I think she's available. I'm not sure she's doing any work right now at the IRS, or anyone else like her, right?
Well, and there's another aspect of this. So we've talked about the unconstitutional text of the bills themselves, the overbroad text of the bills themselves, the incredible new power given to a regulator who can, for all intents and purposes, be entirely partisan, as you laid out. And then there's the other element of when the government gets more and more involved in vacuuming up the identities of individuals engaged in politics is, can we trust them to even keep the information that they pledge to keep confidential? And this is something that an issue in California that arose, I believe under Kamala Harris's watch, that indicates that when the government is vacuuming up personal information, you can't always trust the government to maintain that degree of confidentiality. If you want to walk through some of the shenanigans in California.
Well, we can do that, but we can also look at the Office of Personnel Management.
Well, yeah.
Right? Someone hacked into the OPM database and got all the background information on people that had gotten security clearances. Now, presumably that information was well guarded. I don't know, apparently not, because I know my son got a security clearance and he got this notice that, hey, somebody's got all your information. But
I had a security clearance and I got that same notice, and
right.
3 weeks later somebody was buying clothes at Macy's in Houston with my credit card. Now, I don't know. You
live in Tennessee.
And I live in Tennessee, yes. So I don't know if there's any connection, but
right.
Yeah.
Well, so California, what happened there, to get to California and many states, before you can ask people for money, you have to get a license, which I find offensive to start with. I don't know why the court has upheld that. I don't think they should. But you have to get a license. And California decided, to get this license, we now want a list of your major donors that appears on the schedule that you give the IRS on Schedule B. And California had never asked for this information before. And then what they did is they put it on their website. It was supposed to be in a secure part of their website. And guess what? It wasn't in the secure part of the website. And for some groups, they not only didn't put it in a secure part of the website, they put it in the public part of the website. So anyone that wanted to look up, there were 1,700 groups that fell victim to this. If you looked into their folder, let's say you wanted to research that group before making a contribution, you could have seen the major donors to the group. And it was, most people think it was just, bad management.
Right.
But hey, whoever heard of the government having bad management, right? So it happens all the time. So no, I don't feel comfortable with them getting the information. And in fact, one of the great things that happened last year is the Treasury Department under Trump and IRS jointly announced a new rule that 501c4 organizations, which are the lobbying advocacy groups, the NRA, ACLU, Planned Parenthood, so on and so forth, groups like that, would no longer have to list their major donors on their tax returns that they give to the IRS. The IRS said, hey, we don't need the information. And you know what? They don't need the information because the contributions are not tax deductible. And gift taxes clearly don't apply. So why was the government collecting this information? And the answer was, it had no reason. And so good for them to say, hey, we don't need it, don't give it to us.
One of the things, because I've gone around the country talking about this, and sometimes when you say the words donor privacy, people's eyes glaze over. But when you remind them, okay, one of the questions I tend to ask people is, do you feel more free? For those of you who've been in the public arena, whether it's through donating, through writing, even if it's just through tweeting, do you feel more free now to speak your mind on controversial and contentious issues now than you did 10 years ago? And the answer that I get unanimously is no. No. And it's not because of change in the law. The Supreme Court has been more protective of free speech and arguably has been as protective of free speech as it's ever been in the whole history of the United States. But there's a cultural change that has occurred in this country where there is a priority is now placed not on disagreeing with people, but on punishing people in the public square for disagreement. And I think it's really important for people to understand that when you hear this word, I'm going to say this word, transparency, which is the word that is used to justify these regulations, because who's against transparency? What they're talking about is doxing. That's what they're talking about. And a priority, I think, for civil libertarians from all ideological backgrounds is to articulate a principle that transparency is a value for the government, not for the private citizen. And I'd be interested in your thoughts on this. And one of the things that I think is particularly interesting about the way these laws are so written in such an opaque fashion, the way that enforcement is delegated to unelected regulators, and the extreme intrusion into the lives of the individual, it is the government shouting at the top of its lungs, transparency for thee and not for me.
Well, actually, I don't think that's the motivation at all. The motivation is they want less speech. Mm-hmm. Elected officials want less speech. When Chuck Schumer introduced the first version of the Disclose Act, which is part of H.R. 1, he said something like the prospect of intimidation should not be underestimated. I mean, that's his reason for sponsoring the bill. He wants less speech. And I can tell you, I've worked in nonprofits for years. I know when you try to raise money from people, a lot of people do not want their name on the internet for giving a contribution. There are many reasons for that. One is people are worried about threats, they're worried about harassment, they're worried about simply getting asked for more money from other people is part of it. And a lot of people actually do worry about being targeted by government officials. If you run a business, if you have a tax return, I mean, let's face it, there are so many laws and regulations in this country, right? There's a book called 3 Felonies a Day, where I think it's Harvey Silverglate wrote. And if they want to make your life difficult, if they can get your records and go through everything you do, chances are they can find something you did wrong. So do we want to give elected officials who may disagree with critics the ability to say, hey, I want to find out everybody. It's not just who gave to my political opponent trying to defeat me for office, but anyone that says anything about any issue at all. Do we want to give them that information? Can government decisions be used for that on the basis of that information? How would we ever know? And I mean, to me, that's the real scary part, because of the enormous power government has. But it's also the private sector. And you have to keep in mind, your donations are on there forever. The donation that you made maybe when you were 22 years old may be something you're embarrassed about when you're 45 years old. But yet a potential employer can tap, 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 let's see who this person gave money to over his life. I think what's going to happen is they're not stupid. They know their name is going to go in an online database in the government, in the IRS department, in the local tax department, in every private employer's hands in the country. And they're going to say, why should I give money if it could just lead to harm? And I think that's where we're going to lose speech, because a lot of people are just going to say no.
Well, and there's a fundamental perversion here that I think is really important for everybody to understand. And the fundamental perversion is treating political speech as second-class speech under the First Amendment. You are regulating political speech to a degree that other areas and other arenas of speech are not regulated, not even close. I mean, in some jurisdictions in this country, it's probably easier to open a strip joint than start a 501c4.
It is easier.
It is easier. I wanted to hedge a little bit, but it is easier. And if you told the founders
at least you can get an answer to the question of whether you can do it or not.
Exactly. And if you told this to the founders, if you said that the category of speech in the United States of America that the government is going to become most intent on regulating is speech designed to influence the political process, more so than categories of speech that are designed for pure entertainment, that would have been a surprising development, and that should be a surprising development.
Shocking, I think,
Yes.
would be the right word.
Yes, a shocking development. But it is remarkable the extent to which we have sort of, as a community, as a body politic, have grown so suspicious about political speech and so suspicious about political funding that this issue is just not on people's radar screens.
Yeah. Well, I mean, China has an answer for this, the Great Firewall, right? I mean, we don't need any of this dissenting. I mean, that's really what it comes down to. I mean, it should be robust. We should be encouraging people to speak. We should make it easier for them to speak. And these laws and regulations, I guarantee you, no one's going to be able to figure them out. In fact, I remember the Institute for Justice did a study. They took graduate students, right? These are smarter, presumably, than the average person, one would hope. At least people who can read complicated material. And they gave them a campaign finance manual for a state, I think it was Missouri, and said, pretend you're putting an initiative on the ballot, here's the form, here's the manual, fill it out. And guess what? Like 80% of them got it wrong. 80%. These are graduate students, okay? Now, a lot of speech in this country is, you know, okay, the NRA can afford a lot of lawyers, but a lot of times people just say, you know what, this really makes me upset about what's going on in my community or my county or my township, and I want to do something about it. And they meet in their living room, they start writing checks. Next thing you know, they violated some campaign finance or lobbying law.
Right, exactly.
And usually what happens is some elected official or a lobbyist who's with the elected official figures out this group is starting to get too much of a voice, so they file a complaint and they sick the regulators on them. And in some cases, like what happened in Wisconsin, when you have a vague law interpreted by a partisan person, it can lead to basically a hellish experience.
Yes, and those who forget what happened in Wisconsin, essentially there was an investigation under Wisconsin campaign finance law into issue advocacy, which is a constitutionally protected activity. So essentially a criminal investigation was launched into constitutionally protected speech under this unbelievably bizarre law that Wisconsin had implemented called a John Doe law, where you could be the subject of an investigation, have your home raided in the pre-dawn hours as occurred, armed officers pounding down doors to find out information about constitutionally protected activity. And under the John Doe law in Wisconsin, the subjects of this investigation who'd be raided in full view of all of their neighbors, raided
the ones who were up anyway.
Right, the ones who are up, but they were there for a while. So imagine you wake up and you're in this nice neighborhood and you walk outside and, well, I was going to say to get a newspaper, but nobody does that anymore. You walk outside to walk the dog and your neighbor down the street has 15 cop cars there and cops coming in and out and carrying boxes. What are you going to think? You're going to think, what, drug lord?
Right.
Instead, it was like, you know, pro-life advocate. And under this law, they were prohibited from speaking publicly about the subject of the investigation. They were raided publicly, they were put under investigation, and then could not go into the public square and say, this is what's happening. And it took a friend of mine, a guy with extreme courage, who just violated the gag order and said, hey, this is what's happening, come at me, bro. And it broke the whole thing open. And so this is why you cannot...
And not only that, of course, all the information leaked.
Of course.
So the government, which was supposed to follow this law, did not. Now that reminds me of another investigation, you got a card there, that happened in Montana. The enforcer there is the Commissioner on Political Practices. What an acronym, right? The cop, the speech cop. And the speech cop didn't like this group, went to the bank, subpoenaed all the records, and got all the records, so he had all the checks, and then called a friendly reporter and said, I've got all the information on this group, which was like a labor, anti-labor group. I can't give it to you, but maybe if you ask it under the Freedom of Information Law of our state, I can give it to you. And boom, it was on the front page of all the papers in the state. Information you'd think should have been confidential.
30 seconds to answer this question. Okay. Do you see a distinction in the value of donor privacy for C3 and C4 organizations? And if so, why?
Well, because I think the Supreme Court got it right when it drew the line. Basically said if there's disclosure of contributions, it's disclosure of contributions to candidates and political parties and political action committees, because that's where the potential for corruption is. But a C4 doesn't corrupt anybody. A C3 is a charity, doesn't corrupt anybody. If anything, they're trying to reduce corruption by advocating for changes. And so I think the Supreme Court drew the line in the right place, and that's where the court needs to draw the line again, like, hey, we really meant it.
Well, thank you all very much. It's been a pleasure sharing a little constitutional nerdery with you.